Hello, thank you very much for joining me on another episode of Alberta Self-Determination as I'm traveling across the country, collecting conversations from people all over. Today I'm in the Great Lodge in Ontario with a law professor from Queen's University and executive director of Rights Probe, Bruce Pardy. He's been on the show several times and he's been sharing his perspective of the Constitution, and what we're going to do is get into a conversation about what a future Constitution for Alberta could look like, whether or not we can fix the Canadian one, or do we have to start all over again? Bruce, thank you very much for joining me today.
Jason, great to have you here. Thanks for coming to Ontario. Nice to be with you again.
It's my pleasure, and it's great to be in person with you for the first time. We've been on a show several times,
Right.
but now we get to do this in person and beautiful. We're just off Georgian Bay here at the Great Lodge.
It's a great, beautiful spot. Yeah.
Maybe one day this could be the location of something great in Canada.
You never know.
Well, one of the things we talk about a lot with you is about the Constitution. Is it any good? Do we need to scrap it? Is there another template or format for it? And how can Alberta participate in the process of getting this done?
Yeah.
One of the last conversations we had was Alberta is in a unique position to go ahead and change Canada.
Yes.
And possibly fix Canada.
Yes.
In one way or another.
Right.
What are your thoughts currently as this conversation's been heating up since the election?
Well, I still am of that opinion that that Canada's best chances at the moment lie with Alberta because of Alberta's potential to disrupt the country. I've always said from the very beginning that Alberta should go ahead and pass a referendum and resolve to leave and to cause a kind of political earthquake for Canada, so that if it is within Canada to face its problems, it might have the impetus to do so. Now, that might or might not happen. Alberta leaving might also cause a domino effect for other provinces, other regions. That would be good as well. But in some way, Canada needs to be disrupted because the status quo is not working. Certainly it's not working for Alberta, but it's not working for Canada in general, in my opinion. And so the vested interests in this country have to be disturbed. And so we have an opportunity to either start again or for the various bits to go their own way. I don't know which of those two things is going to be. It's not important to know that right now. What's important to know is that the present situation won't do, and that there are no better alternatives at the moment than the path that Alberta is on. So I hope that they will succeed.
So I like the way you laid that out. We don't know how we're going to get there, but change is needed.
Correct. Change is needed, and including to the Constitution. Like the Canadian Constitution, there are good things about the Canadian Constitution in the broad context of things. In the broad context of human civilization, the Canadian Constitution, ain't so bad. But in terms of what we expect for this country, it is proven that it doesn't work so well now. And if Alberta goes its own way, then one of the things, in my opinion, that it needs to do is to leave the Constitution as well as leave the country. I do not think it's a good plan to try to adapt and fix the Canadian Constitution. Start again. You're starting again with a new country, if you get to that point. Start again to reimagine what the country should be, how you're going to govern yourselves, how you can create a new and better Constitution, one that's not existed before. My recommendation so far has been to turn to the American Constitution. The American Constitution has better constitutional architecture than the Canadian. Start with what they've got. Use what worked in the American Constitution. But the American Constitution also has some problems. And so this is a chance to use what worked and fix what didn't work, to reimagine it from the beginning, to start with a blank slate, a clean table, and say, right, so what are the choices here? And so let me put the choices in a very broad way. The Constitution that we have right now in Canada, and for that matter in the States as well, offers us two bad choices. And the two bad choices are be ruled by elites or be ruled by the mob. Neither of those two things are very good. I hope for obvious reasons. But you don't want to be ruled by a bunch of powerful elites. We had that when we had a king. And over a very long period of time, we learned that that doesn't work very well. And in a very long and slow and painful process, we took power from the king and we gave it to legislatures. And that sounds great because the legislatures are elected by the people, okay? But the people are also a mob. And you don't want your own freedoms to be dictated to by the mob, right? And so the Americans came along and they introduced the Bill of Rights. And the Bill of Rights, as with our charter, establishes certain individual rights that the majority, the mob, the legislature, is not supposed to be able to intrude upon. And that's great in principle. But the problem is that as soon as you do that, now you've given power to the courts. And the courts interpret the words of the Constitution and tell us what they mean. So here's what we've done. We went from king, which is an elite, to the legislature, which is the mob, to the courts, who are an elite, right? Elite, mob, elite. And it won't do just to keep going back and forth between the elites and the mob. And right now we have a combination, right? We have majority rule in theory. The legislatures represent the people. They're elected, I suppose. But we have this combination now of rule by legislatures and rule by the courts. And neither of those two things is very good. What we don't have yet, what we have not been able to achieve, is a very clearly demarked area of individual autonomy where the legislature and the courts cannot go. Now, this is a difficult problem, right? Because you think, well, somebody has to have the last word. Somebody has to be able to tell us all what the law means. Somebody has to be able to control the force of the state. But this is, if you like, the topic, the task in front of us. If you have a new chance to create a new country and a new constitution, how can you imagine the constitution where individual people and their families actually, I mean, genuinely have the individual autonomy to do as they think best, as long as they don't encroach upon other people? Then they should have their own way. How do you ensure that that is the case without interference from either the mob or the courts?
So you're envisioning basically two massive changes, the Constitution itself and the judicial system as well. They kind of need to work in tandem, but differently than it works now. So the power doesn't end up with, let's say, the mob or the elite or the courts.
Right.
So starting with the Constitution portion of it,
Yep.
Is there a current Constitution somewhere in the world that mimics where you're going with this, or are we talking like completely scrappy and starting from something fresh?
Well, I think you should completely scrap the Canadian Constitution. I don't think you should scrap the American. I think you should start with their bare bones. Their bare bones is very good. They have a better separation of powers than we do. They have, so they in the Western world generally, certainly the Americans and the Canadians and the British, they split the state up into three bits. Yes, the legislature representing the people, the executive, the bureaucracy, and the courts. And the Americans have a better separation of powers between those three branches than anybody else. In our system, the same small group of people control the legislature and the executive. So you have the prime minister and the cabinet. They sit in the House of Commons. They control the party that they lead, but they also are the heads of all the ministries, right? So it's technically separation of powers, but it's not very distinct. In the American model, you have Congress, two houses of Congress, elected representatives, and you have the president. Now, the president is the head of the executive branch, does not sit in Congress. Yes, has a veto, but is not otherwise directly involved in the legislative process. You have a distinct legislative branch and executive branch, and of course the courts. So that architecture is better than ours, I think. So you start with that. You don't toss out the whole thing. But then you say, well, even in the American system, that system has allowed some things to happen which are not that great. For example, the Americans, like us, have a managerial state, an immense bureaucracy, a huge federal government with hundreds of thousands of employees that dictate what people do in all different phases of life. We have that too. The American Constitution has not been able to prevent that from happening. And so we need to step back and say, basic situation is good, but what is it about the American Constitution that allowed that to occur? How can we draft it better so that we manage to carve out an area of liberty for every individual that will not allow this state apparatus to intrude upon and tell them what to do? So that's a interesting, important task to perform.
So that's the architecture. That's the infrastructure and the checks and balances. And at least we're introducing another level of check and balance when you have the executive separate from the legislature, from the courts. Okay, how about the Bill of Rights and Charter?
Yes.
That particular document, which is meant to protect from mob rule.
Yes.
How's that been working?
Right. Well, so the Americans have had a better experience with theirs than we have. But the basic architecture is similar. The difference, what's common in both, is that in both situations, it's up to the courts to interpret the words of the Bill of Rights or the Charter and tell us all what they mean. Because, the Charter, as the Bill of Rights says, you have freedom of expression. Okay? Well, that's great. So we all have freedom of speech. Except that we don't know what that means. We think to ourselves, well, I know what freedom of speech is. But actually, do we? So let me give an example. I like to use this example. Somebody comes up to you on the sidewalk and says, "Give me your wallet, or I'll stab you in the heart." Okay? Well, that's speech, right? Now we all know that that's not right. That's an offense. That's assault. Okay? You're threatening with violence. But the Bill of Rights and the Charter says free speech, and all the guy did was talk to you. So how can it be an offense? Because the Charter guarantees the right. The answer is, it doesn't mean what it says. There's a line in there embedded in freedom of speech somewhere between free speech that is protected and speech that is not. So everybody, I think, accepts that you shouldn't be able to threaten violence. But there are other kinds of exceptions to free speech as well. And here's the kicker. It's the court that decides where the exceptions are, where the line is drawn. And nobody knows before the court tells us what the thing actually means. So our right to free speech, as with all the other charter rights, depends almost entirely on the court. The Charter does not dictate this. The court does. The court is deciding where our rights are. And they decide these things differently in the states as in Canada. So our courts, our Supreme Court especially, tends to be a progressive court. The Americans have a much more mixed experience with their court. It's not one way or the other. They have a mixture of justices and courts over a period of time, leaning one way or the other. Their free speech jurisprudence at the moment is much better than ours, in my opinion. They carve more things out and say, no, you can't intrude there. Whereas our courts have said, yeah, you can have a prohibition on things like hate speech because, hate speech is not a good idea. Our Supreme Court tends to, and actually the American does as well, tends to define free speech in a utilitarian kind of way, in the sense of, well, speech that is important to the general good, as in it promotes democracy, is protected because it's important, but other kinds of speech, maybe not so much, so we're not going to worry about that. Okay? That's not free speech in my books. Free speech is speech in where you can say what you think for the sole reason that your thoughts are yours. And that's all, as long as you're not threatening violence or intruding upon somebody else's rights. Okay? If I had been the court, that's the way I would have interpreted it. The point is, it's open to interpretation. And if that's the case, then you don't know what your Constitution means until it's too late. So that's one of the things that has to be fixed. How do you design a Constitution differently so that the elites sitting on the court are not the ones dictating to everybody from now on how far your rights go?
All right, so how would you change that? Because when I talked to Brian Peckford, Honorable Brian Peckford, he says the Charter has been abused because it went from God-given rights, which he really thought people would understand, that God is supreme, to what I would call government-given rights. So when people look at the Charter, the way they interpret it is, here are the rights given to me by my government. Would you flip that model so that it's restrictions on government versus restrictions on the people?
Yes. So this is a very good first step in imagining a new constitution. The constitution that we have now is built in this way. It has a default, and the default is the state can do anything. Its powers are unlimited. It can provide for the general welfare. Now, there are divided jurisdictions between the provinces and the federal government. That's fine, but that's not what I mean. The state as a whole, if you include the federal government and the provinces and all the other bits of the state's powers are unlimited, except for those rights as set out in the Charter. So it's unlimited except. Okay? And what I've been suggesting is there might be a way to reverse that default. Instead of saying unlimited except, say the state has the power to do nothing. It is powerless except. Because there are some things you want a state to do. You want the state to keep the peace. You want the state to protect you from invasions from outside, and so on and so forth. So you don't want to make the state completely powerless because there's no point in having it then. But if you establish that as the default position, the state can do nothing that's not specifically listed here, and that if there's any question, if it's not listed, then you can't do it. If you do it that way, then you actually don't need a charter or a Bill of Rights, because instead of carving things out of that unlimited amount of power, now the state's only allowed to do certain things, so you don't need to prevent it from going further. So that's one of the ideas about how to approach a newly envisioned constitution.
I like that a lot, because when I'm thinking about it, like, how would this work? So we'll take an easy one: life, liberty, and pursuit of happiness.
Right.
So that seemed to be the right of everybody. You have the right to life, liberty, and pursuit of happiness because it's written as such.
Right.
This is stealing from the U.S. side of things.
Sure.
But if we flip that, it would be, well, that's the default. That's already assumed. But the government can remove your liberty, for example,
yes,
in the condition of due process, in the commission of crime. Here's how you could lose the default right of liberty.
Right.
And this is the kind of way you would lay it out along those lines?
Yeah, along those lines. But so liberty is a very good example, though, because, it seems so obvious at the beginning. You look at the word liberty and you think, well, of course, that should be for individuals. Okay. But then you don't want to hamstring the state too much in this sense. Let's say somebody commits a crime. Let's say they murder somebody. Okay. Well, you want the state to be able to prosecute and convict and imprison the person. And if the Constitution says liberty, and there's no powers of the state to do those things, well, then the person who committed the murder can say, no, I have a constitutional right to liberty. You can't imprison me. And it doesn't say that you can use due process to convict me and throw me in jail. So you're stuck. Right. So it's got to be very deliberate, and we have to do this with open eyes, because we can't take too much for granted and assume too much. Yes, we want people to have liberty. We want individuals to not be imposed by the state, except, and it's the exceptions that are the problem. You've got to provide for the state's powers to do the things you actually want the state to do and do well. But you don't want the state to be able to overreach in those other areas. So back to life, liberty, and pursuit of happiness, you don't want the state to have the power to, as it's doing now, to basically interfere in everything, to interfere in all walks of life, interfere in all industries, interfere with, licensing requirements and taxes and reporting and surveillance. And you just don't want that to be able to happen, right? So you've got to be able to describe precisely and succinctly, but in a binding way, where the line is between what the state can do in the pursuit of its legitimate objectives and where it's totally out of bounds, in a way that the courts will not take and run away with in a direction that you don't want.
Let's take another one, for example, because it's fun to digest and break down. The right to bear arms. So
right.
In the United States, there's the Second Amendment that says they have the right to bear arms to form a well-armed militia,
right.
Yada, yada, yada.
Yeah.
And that's basically giving by the act of the Bill of Rights or the amendment, the right to have firearms. Under this new flipped model, it would be assumed, yes, you have property rights, including gun rights,
Yes.
but you could have something in there that says, upon conviction, yes, you lose or limit a certain right.
Right.
And that's how the wording could be, because it would be, you have it until or unless or except when the government has reached some sort of threshold.
That's correct. That's correct. You do not want to establish a situation where everybody has the right to have firearms at all times, because that means you're including the bank robbers, right? That doesn't make sense. On the other hand, your first point is absolutely correct, because if you flip the default, you don't need to say that people have the right to bear arms, because it's one of those things that the state is not able to do as a matter of course, is take away your guns. So yes, it's a matter of drawing lines, and this is the trick in writing a constitution. You have to be able to draw lines that make sense and are very clear. Those lines are not clearly drawn in many cases in our constitution. Let me perhaps refer to a proposition that I've run across several times about new constitutions. People are often fond of the idea of having citizen referendums to decide legislative questions. So whenever there's a law proposed for X or Y, we should put the question to the people. Okay? And there may be situations in which that is actually not a bad idea.
Like separated from Canada as a state.
Exactly so, right? You ask the population of the province or the region whether or not they're happy being a part of the country that they belong to. Fair enough. There are some things that should be subject to majority rule. But there's also a danger, right? Because now we're back to the mob. And we're even more of a mob now in this model than the legislature. The mob elects the legislature, and then they do their own work. The citizen referendum is direct democracy, which makes it sound great, and sometimes it is. But it's also mob-like. So sometimes I put it to people this way. If we had direct democracy, if we had referendum during COVID, and we were deciding all our questions that way, like forget the charter, we're going to decide what we're going to do during COVID by referendum. So fine. Now, here's the question. Does everybody have to get a vaccine? Now, if 75% say yes, right, then everybody is vaccinated or in prison. Okay? That won't do. That is not a free country. Now you're being ruled by the mob. Okay? So it's a good idea, but again, you got to be careful with the powers that you give to it.
I'm sure if you did a referendum question, should we eliminate all taxes altogether and provide no money to the government, majority might say, yeah, we absolutely should do that.
They might, until you went on and said, oh, by the way, that means no this and no that and no this and no that. Like no public schools and no healthcare and no police and infrastructure. I mean, all those things that the state now provides. If you eliminated all taxes, I mean, we're not just income taxes, but all taxes of any kind, then the state might not have any money, and therefore all the things that it does would have to stop. So taxes are a problem. I'm as you know, I am not a fan of taxes. I'm really not a fan of income taxes. I think we should get rid of that. I hope Alberta will have a serious conversation about getting rid of income taxes. But it always comes back to the same basic questions. All right, so what do you want the state to do? Minimal, I hope, but not nothing. So if you're going to have a minimal state and you're going to have no income tax, then the question is, okay, so how are you going to fund the minimal things that the state's going to do? That's a fair question, and I don't have an easy answer to that, but at least already we're away from the model that we now have. And that's what you want to try and do. The whole Alberta thing is to get away from the status quo. And so if there's a message here, it's don't cling to the status quo. In trying to get away from the status quo, don't cling to the status quo. It takes a little bit of courage and an open mind and some exploration and an adventure to find a different way to do things. And that's the whole purpose in this enterprise. Yes.
Okay. Section 9192, the
Yeah.
separation of powers,
Right.
jurisdictionally, provincial, federal. Was that along these lines with an attempt to say what powers these jurisdictions have? Because we saw overreach there and we saw abuse there.
Yes. So a federal system is tricky. We have one here. They have one in the States. It's much simpler to have a unitary government where there's only one level of authority. Like essentially, well, they sort of have that in the UK. Maybe they now have. I wouldn't call it a confederation, but they have powers, Scotland and Wales and so on. But New Zealand perhaps is a better example. It's a unitary state. There's only one level of government. There's no provinces. Yeah, they have cities, but cities are essentially a level of government that is created and authorized by the central government. In our country, a municipality is not a constitutional level of government. It is not federal, provincial, municipal. It is federal, provincial. End of story. And the municipalities exist and have their powers because they are created by the provinces. And so if you get rid of provinces, and if Alberta was an independent country, I mean, you could have provinces inside Alberta if you wanted to, but there's no need to. So just have Alberta as a unitary state and have a government without the federal complication. And then you won't need a 91 and 92. You won't need to split the areas of jurisdiction between the levels. The division of powers in the Canadian Constitution has been a problem from the beginning. There are so many court cases about whether or not the province or the federal government has jurisdiction over this or over that, or whether it's overlapping. If it's overlapping, who takes precedence, paramountcy. It's like it's one of the Canadian things that we do, and we'd be better off without it.
So this could be an opportunity to sit down and really rethink government and end up with a far smaller government.
Hopefully a way smaller government. One of the great things about how Albertans are speaking about this problem is that they say they want to live in a free country. Great. I mean, thank God for that. Okay. But free is a big word. Like, okay, it's good, but what do you mean? Do you mean just free from Ottawa? Or do you mean free? And of course, people have different images of what they mean by that word. But I hope that most of them mean that their government is not imposing upon them, not directing them, not insisting that they behave in certain ways, not insisting that they believe in certain things, or that they speak in certain ways, or that they raise their children in certain ways. I mean, it implies a significant degree of autonomy. I hope that's what they mean. But if it is what they mean, then there are certain things that now exist both in Canada and in Alberta that are not consistent with that vision. An awful lot of things in Alberta are not consistent with living in a free country. I mean, in Alberta, like in Canada and everywhere else in Canada, in Alberta, you have a managerial state. You have a big bureaucracy that develops policies and rules about everything under the sun and tells you what to do and manages this and directs that and supervises this and requires you to report and tax and file. And this is one of the things you don't want. And so the process of becoming independent, I hope, will include the realization that, yeah, you're leaving Ottawa on all that stuff behind, but you also have to leave the same stuff behind that's inside your own province right now. Okay? And that means, as you said, that means starting again. What is it about how we govern that doesn't work? Not just in Ottawa, but also in Edmonton. We want a much smaller government. We want a government that doesn't do all the things that it's doing right now. And my favorite example, I keep going back to it because it's one of the ones that people are stuck on, is healthcare. Okay? If you want to live in a free country, and you mean that in the autonomous sense, you cannot have a single-payer public healthcare system. Those two things don't match. Your healthcare system has to change. You have to allow people to buy their own healthcare. That's part of what being free means. So to those Albertans who are thinking, well, we want to become independent and free, but we want to keep the healthcare system, my message is, you haven't thought this through. That's not consistent. Maybe you just mean you want to be free from Ottawa. Okay, fine. I mean, that's a choice, but that doesn't mean very much.
Do you think at this time on the Constitution, Bill of Rights level, this is a time to really start drafting and thinking about it, or do we need to maybe take the step of the referendum and focus on that first and get that question answered?
I don't think there's any harm in thinking about it and drafting. I understand that there are some drafts in the works. I'm working on one myself. I think it's great to have the conversation. I don't think we need to finalize it or anything before the referendum. I would recommend that we don't try and do that, really. The referendum is job number one, to try and convince a critical mass of Albertans that this is the right way to go. But we shouldn't hide the constitutional question under the rug. There are things we need to talk about, for sure. And the earlier that we start that work, the better, so that when the time does come, there are things in the works and we're not starting from scratch.
Okay. So on the constitutional level, there's some things to work on. We can start drafting, thinking about it. Don't finalize till we get there, and really have the real big question of what does freedom really mean? What does free really mean to you?
I think that is one of the biggest questions for everybody involved in this. All of the citizens of Alberta who thankfully are inclined to believe that they want to live in a free country. Well, we should ask them that question. Great. What does that mean? What does that mean to you? What is it like to live in a free country? In what ways is the country that you now live in not free? Because I agree with them about their perception. This country that we live in, Canada, has become not such a free country. And people in Alberta, thankfully, recognize that. So if that's the case, so what is it about Canada that has now made it not so free? And how do we fix that?
Would things like a free market be in the Constitution, so it's very clear that the government stays out of private market, free market?
I would like to think so, and this is part of the default, right? So interfering in markets, and I don't know exactly the exact wording yet, or how to put this so that it works, so it binds, so it's actually effective. But managing markets, central planning, all of those things that governments do with economies shouldn't be part of what they do. And the default position is, look, the state can do nothing other than those things that are specifically listed here, and everything else is up to individuals. That is one of those things. Commercial transactions. The free market should not include the state. If you and somebody else want to transact for something, and you can agree together voluntarily, well then, why is the government involved? You just do it. That's what free people do. So yes, the short answer to your question is yes.
Because if you do want freedom, true definition of freedom, that means stay out of the markets, stay out of healthcare, stay out of education, even stay out of the families or the incomes or the way people want to live. Now there's limits. There's always going to be limits, because freedom for one person might not be the same thing for another. For example, somebody might think they have the freedom to kill.
Right.
And I think a lot of people would agree that's not one of these freedoms that we're talking about here.
Right.
Because I have a freedom to live.
Right.
I have the right to live. So how do you balance those kinds?
Right. So I like to define it this way. And of course, as you point out, there's more than one way to skin a cat. But my definition of freedom is this. Freedom is the absence of coercion. Right? So if nobody is coercing you, that is, applying force to you or the threat of force to make you do things or to punish you or to hit you or to cause you harm, like there's the absence of force. The interactions with you and your next person are voluntary. That means they can't do anything to you without your consent. Okay? That's the state of being free. Now, if you live in a free country, that means you are subject to the coercion of no one, not your fellow citizens and not the state. Okay? The state's job is to ensure that that's the case. So the state's job, in part, is to prevent the coercion of other people. People can't murder you. People can't beat you up. People can't threaten violence. People can't use force in any other way to make you do what they want you to do and you don't want to do. That's coercion. That's not free. Okay? So if we define free that way, that means by definition, no, you're not free to kill your neighbor. That's a violation of their freedom. And freedom is a universal and mutual condition. Your freedom and their freedom have to coexist. And that's where we draw the lines.
So the government needs to get out of defining freedom, but needs to protect freedom.
The freedom should be defined as well as we can in the Constitution, and not leave it up to individual governments to decide, how far they think it should go this time. And that's what happened during COVID, right? So one of the things that the government is not generally, or should not be generally, authorized to do, empowered to do, is to provide for the general welfare. And that's the thing that governments think that they're empowered to do now, basically all the time. And frankly, under our existing Constitution, they are. And people even think that people think that governments exist to provide for the general welfare. But if you give them that power, then they end up doing all the things they're doing now in the name of the general welfare. I mean, it was the general welfare that served as the ground for all the COVID policies. We're providing for the general welfare. Okay. Well, the general welfare, depending upon how the government defines it, comes to be in direct conflict with individual freedom. We are imposing upon you, because we don't want you to do that, because you are now infringing upon the general welfare. Well, sorry, I have the right to do this. And it is not within your power to tell me what to do for the general welfare. Yes, in order to protect other people's freedom. I can't go around hitting people. I'm not free to do that. But that's not the general welfare. That's protecting that person's freedom.
Well, it provides an easier mechanism, I think, to wrap your head around what the interpretation of these words will be.
Right.
Now, one of the challenges can be, though, is still going to be dispute.
Yes.
So now the judicial side of things, where we're trying to dispute resolution.
Right.
How does that look in
right.
a new country?
Good question. Okay, so let me go back to the beginning where I said two bad choices: to be ruled by the mob or ruled by elites. And you don't want either one of those two things. We've been talking about the mob. Let's talk about the elites, because the courts are one of those elites. Right? You don't want an all-powerful court telling us all, what the words mean and how it's going to be, from now on, because we have a Supreme Court, and the Supreme Court is, if I can put it this way, with respect to certain questions that arise in cases like what the Charter means, the court is all-powerful in the sense that you can't appeal from what the Supreme Court has said, and you can't change the Constitution because it's so hard to change in certain respects anyway. Okay, so you have these 9 people who have an awful lot of power. They are an elite. Okay, so how do you not create such a concentration of power? Okay, well, there are a couple of possibilities. Number one, you provide for what I like to call amateur government, an amateur state, which includes the courts, but it also includes the politicians. And by an amateur state, I mean not a professional class of people. In other words, a very limited time for appointment. Imagine this. Imagine that your Constitution provided that people who sat as judges on courts could do so for a maximum amount of time. Let's say 5 years. You could pick any number, but let's just say 5 years. If you're appointed to the Supreme Court, you sit on the court for 5 years, and 5 years alone. None of this be appointed when you're 45 and sit till you're 75. 5 years. It's very brief. And that means you get turnover. And you get no particular individual who becomes the court. They personify the court. Now we have judges sitting for a long, long time. And they are very powerful people. They get to dictate what our laws are. Even more, in some respects, than our legislatures do. Right? So limited time. That's the first idea. And we can apply that idea to everybody who works for the state. Let's just imagine how that would work. Politicians, now people have made the suggestion for politicians a lot of times, and then there's some appeal to it. It already applies with respect to how many times you can run for the presidency of the United States. But apply the same idea to everybody who runs for office, for any state position, in any legislature, can do so only for 4 or 5 years. So that means if you become an MP, and you sit in the House of Commons for 4 years, well, okay, that's great. Now you're done. Away you go. You can't run again, ever. If you're the Prime Minister for 4 years, great. You do the thing, then you're out. Okay? You get turnover. You don't get any professional class of people. Try it for bureaucrats. If you work in the bureaucracy for the state for 4 years, fine, great. Work for 4 years, then you're out. Okay? There is no established elite inside the machinery of government. There is no deep state because there's nobody there who knows anything about it. It's amateur. This is not a professional class of people. Amateurs. And while we're at it, let's pay these people, whether or not you're a bureaucrat or a politician or a judge. You know, everybody says they do these things for public service, right? But in the meantime, we're paying them a lot of money. I suggest not only do we limit their terms, but we pay them whatever the median wage of the jurisdiction is. So if it's Alberta, you pay the bureaucrats, the politicians, the judges, and anybody else the median wage of Alberta. So you don't do it for the money, and you don't do it for the power because you're not there very long. You do it for the public service. And if you don't want to do it for the public service, then don't do it. But we'll get a lot of more people involved in government. They will understand that it is to their benefit, individually, to have the government work for the people because they're going to become one of the people again very quickly. There are no vested interests who are stuck in there and can't be removed. And in those respects, you start to diminish the idea of having a state elite. There's no embedded interest. The lobbyist industry starts to not work so well because you're dealing with a new person next year, and then they won't be around for very long. Right? So there are ways to structure this so that you minimize the degree to which your state becomes a problem. That's the first thing. The second thing is we might think about changing who makes decisions and what they are. So right now we have courts, public courts with appointed judges. Okay. Independent courts. And to some extent, independent courts have been a good idea. Certainly, it needs to be independent of the executive and the legislature. But they become a power unto themselves. So next question is, all right, well, could we also make use of some kind of a private adjudication system? Could people who are in disputes be constitutionally mandated to go and find their own adjudicator? Now, people who are in disputes are going to be in dispute about that too, right? Which is maybe why you need courts. You need courts to resolve the procedural problems in the private adjudication. Now, I don't want to get too much into the weeds on this. This is just an idea. It has potential. The details will obviously have to be worked out. But the point is, what we're trying to do is to disperse power. The more power is dispersed between a whole lot of actors across the spectrum and through time, the less threat the state can become. And here's the bottom line. At the moment, the state itself, this thing that is supposed to be protecting our freedom, has become freedom's biggest threat, right? And so the task of this new constitution is to develop a model where that is not possible, where it's able to protect our freedom, but it's not possible for it to become freedom's biggest threat. That's the combination that you need.
I like that because you're providing a framework for the procedural side of things. And if there's disputes about how to deal with the procedure, that's where you can get the courts involved.
Right.
But you'll lose things, and probably by design, things like judge-created law and decisions by judges that have precedence going forward.
Right.
And that might be a good way to satisfy the idea that the courts have power, at least on that level. But if there's a dispute and we don't have a way to figure out who's going to mediate this or adjudicate this,
right,
courts could be there to help us decide that.
Right. So let's identify, if you like, let's put it this way. One of the foundational ideas of our Western thinking about it, all of this, is that the state has monopoly on power, on force. The state has monopoly on violence. And that's the thing that makes it work, because the state can come along and say, well, you misbehaved, we're going to throw you in jail. And the reason we can throw you in jail is we have the guns and you don't, or at least if you have guns, then you're not allowed to use them. Right? It's a monopoly on power. Now, you can't have that monopoly open to just anybody to use, because that becomes anarchy. The violence can't be used by the most powerful person, because that's anarchy. So how do you control the use of the state's force so it's used for the proper purposes and not for improper purposes? And that's one of the things the courts do. Courts control the force of the state. When they give a judgment and say, that person is convicted of this crime, or this person owes this person this amount of money, the force of the state can be used to enforce those judgments. So you can't do away with courts altogether. But what we can do is say, well, can we put courts in the role of making procedural decisions instead of substantive ones? That is, do we really want to give courts the ability to give content to the law? Because they're doing it right now in Canada, and doing it in a way that me and a whole lot of other people think is not great. Okay? So is there a way to take that task away from them and yet still have them as the gatekeepers of the state's force? And one of the possibilities, as you allude to, is to put it into a procedural role, as in, this dispute is being resolved over here by a private adjudicator. There's a procedural dispute about how that's happening. Now we'll go to a court and have the court tell us how that procedure should be fixed. Or if there's a judgment over here and the judgment needs to be enforced, now let's go to a court and have the court give its okay to have the state enforce it with its violence. So we're trying to disperse power.
I like that. And so on the civil side, we have common law and hundreds of years of common law, kind of working our way through some of this stuff like torts and stuff like that.
Yes.
And then on the other side, we have criminal code, where we kind of laid out thou shalt not and a whole bunch of these things here.
Right.
Would we start from scratch on these, or would we kind of adopt them and work with them?
Well, this is one of the questions that needs to be answered. My inclination would be not to throw the whole thing out. I mean, the common law has been very good in many ways. And part of the reason people like the common law is that it has been evolutionary. It came from the common people originally. I mean, that was sort of the idea. It has long not been that. It's been judge-made law, as you allude to. Now, a lot of it is very good, but a lot of it is also a little bit manipulated, certainly controlled by the courts. And it's a little bit also, it also pretends to be things that it's not. So it is certainly not hard and fast. It's very uncertain. And in that respect, it's not great, because people expect to have some degree of predictability in their law, and certainly in recent decades, courts have not been able to provide that very well. So you don't want to throw the whole thing out, but on the other hand, you don't want to put the whole thing in the hands of the courts to essentially sort of make up as they go along. This is the irony. If you give the courts the ability to decide things as they think right in the cases that come before them, then you have done away with the rule of law, because the idea of the rule of law is that the same rules are being applied to everybody in every case. And in order to do that, you need to know what the rules are ahead of time. You can't decide after the fact, well, in this case, the rule is going to be this, which is sometimes what happens in common law jurisprudence. You get a new situation that doesn't quite fit the precedents, And now you have to figure out how the rules are going to be not broken, but maybe massaged so that it fits the new scenario. Okay. Sometimes that's unavoidable, but not always. Right. So back to your question, do we adopt the common law or get rid of it? I wouldn't get rid of it, but you might adopt it and say, we're going to keep the content as a guide for the adjudicators who are going to decide these cases, but we're no longer going to have a system of precedent. The adjudicators, these private adjudicators, are not setting precedent that bind all the future adjudications, because that's giving them too much power now. They're just going to decide it the best they can on the basis of the jurisprudence that we have. Okay? Now, I grant you, there's still a lot of uncertainty in that. But that uncertainty might be unavoidable. I'm not sure that we can design a system that is totally certain, because that defies the nature of language. I mean, law is written in language, and language is inherently ambiguous. So it's very difficult to write something down and to make clear what it means to everybody, because not everybody reads words in the same way.
So it feels like, just hearing this come out, like if adjudicators are taking it basically case by case and they don't have binding, or they don't create binding or precedents, that's justice now. We actually have justice at that level.
Yeah.
Because it's a case by case, what happened. We have some guidance, but we were looking at the case, and that feels like it'd be closer to a justice system versus...
Well, perhaps. So in a way. So here's the tension, though, with that term justice. So it can be both good and bad. If you have a rule of law system and you apply the rules of that system to a case and get an outcome, and the outcome, it doesn't look very fair, then it looks like a legal outcome, but not a just outcome. Okay. However, on the other hand, if you just have case by case adjudication and you have people just deciding what they think is fair, then everything becomes random, and there are no rules, and therefore there's no rule of law, and therefore everything's a wager and a chance. That's not really a great system either, right? So there is this tension between the rule of law and the idea of justice, and somehow we have to reconcile those things so that people are getting justice, but not getting it in a vacuum.
And kind of the final question here, and I think it's going to be a bit of a controversial one.
Right.
These adjudicators, human.
Yeah, right.
What about non-human adjudication?
Yeah, well, AI is going to continue to advance, and it's already doing some remarkable stuff. It's not quite ready in the legal sphere, but I could see how it could become ready. But here's the kicker for AI, of course. Humans write the program, the algorithms, the means by which the AIs learn all start with human beings, and those human beings have biases. So what you don't want to do is give over your legal system to an AI that's written by somebody and nobody exactly knows what the biases are that are embedded in it. So yeah, it has potential, but it's also got some dangers.
And one simple example of that would be photo radar.
Yeah.
You don't know who the driver is,
right?
But the owner gets to take it.
Right. Sure.
So that wouldn't be just.
Right.
Because whoever's doing the driving should be able to take
right.
it. So there's an example.
And that example, again, put your finger on the problem and the tension, right? Because sometimes to get a result that seems just, you need a human being to exercise discretion. Problem is that discretion is also the greatest source of injustice. So it's got to be controlled discretion, and this is the $40,000 question. You know, how do you allow for just enough discretion in a system to get justice, and not so much that the power can be abused?
That is a 40,000, maybe the 40,000 Alberta dollars question.
Right.
Maybe one day. We'll get into that one another day.
Right.
Do you have final comments for Albertans?
Oh, just carry on. I mean, good luck with this enterprise. I'm hoping I'm able to help, but I hope that you are resolute in your determination to fix the situation that you know not to be right. Don't put up with anything less.
Thank you very much for your time today.
My pleasure. Thanks.
Thank you. Well, there you go, Alberta. From the Constitution to the common law, don't throw the baby out with bathwater. There are some great examples out there to start with, but now's a good opportunity to go really think about this and see what it is that you want. Do you want a justice system, a legal system, a just system? Do we want to change the courts? Do we want to remove the power and where the power should be? It's a tough question, and there's a lot of good conversation here, so I hope you think about it. Well, thank you very much for your time. Make sure you share and like this video, and there's a lot more to come. You take care of yourself and each other, and God bless.